Real estate transactions may seem like the ultimate situation where the childhood rule of no takebacks applies. But what if a deed contains a condition subsequent that allows the original owner to reclaim land if certain conditions are met? In Red Hill Outing Club versus Hammond, we'll see whether landowners can take back a ski slope that they deeded to a ski club. David and Elizabeth Hammond purchased a plot of land known as Red Hill in Moultonboro, New Hampshire. The Hammonds installed a rope tow and began to use Red Hill as a ski slope. The Hammonds also helped form the Red Hill Outing Club. For over a decade, the club leased Red Hill and operated the rope tow. The club also provided free ski lessons to residents. In 1979, the Hammonds conveyed the Red Hill property to the club. The deed specified that, quote, "The premises shall be maintained and made available to residents of Moultonboro as a ski slope," unquote. The deed contained a condition subsequent that allowed the Hammonds to retake possession of the property as soon as a legal action was filed if the club failed to provide skiing facilities for 2 consecutive years. In 1988, the club stopped offering free ski lessons. From 1992 to 94, the club didn't obtain a permit to operate the rope tow. The club closed the ski slope during the 1993 to 94 season. In 1994, the Hammonds filed a notice of re-entry and possession, claiming that the club breached the condition subsequent when it failed to provide skiing facilities for 2 consecutive years. In response, the club sought a declaratory judgment against the Hammonds. The trial court held that the club met its contractual obligation to provide skiing facilities because the club made Red Hill available to the public. Closing the ski slope from 1993 to 1994 wasn't a long enough closure to be considered a breach. The Hammonds appealed.